Okay, hello and welcome everyone to our webinar today on trademark oppositions, tips for business owners. My name is Sophie and my co-host today is Graci, and we are both senior lawyers in LegalVision's trademarks team. So before we begin, a couple of quick housekeeping items. You'll receive the recording of today's webinar and a copy of the slides in your email to refer back to later. Feel free to submit any questions in the Q&A box as we go, and we'll do our best to answer them at the end. And we'd be grateful if you could complete the feedback survey after the webinar finishes today. For the next 48 hours, you are also eligible for a free consultation with LegalVision to discuss how we can help your business. So if you'd like to provide your contact details in the survey at the end of this webinar, our team will be in touch to organise your consult. All right, so today we'll be discussing the different types of oppositions in Australia, what it means if your trademark application is opposed, some reasons why you may want to oppose someone else's trademark application, the different grounds of opposition, the opposition process and some procedural matters, and then we'll finish off with some Q&A. So Graci is going to start by discussing the different types of oppositions in Australia.
Great, thanks, Sophie. So to begin, I'll briefly run through the different types of oppositions that can be filed through IP Australia. So in Australia, there are four main scenarios where an opposition can be filed. So it can be filed against an application to register or protect a trademark that has been advertised as accepted. It can be, there could be oppositions against an application to the removal of a trademark for non-use, or what's called a cessation of protection for a trademark filed under the Madrid Protocol. There can be oppositions against an application for an extension of time of more than 3 months. And there could also, in some scenarios, be oppositions to an application or request for some amendments to a trademark application. So that could be amendments to trademarks to correct misspellings or amendments to the classification, including the wording of certain goods or services. So the most common oppositions that we see filed are the first two. So that's where a party opposes to prevent the registration of a new trademark application or to remove a trademark from the register for non-use. So in today's webinar, we'll focus on oppositions to the registration of a trademark. So this is a formal objection to the registration of a trademark that has been accepted by IP Australia. So once a trademark has passed the examination stage and has been accepted and advertised, any person can oppose a trademark application within a 2-month period. Important to understand that only once a trademark has been accepted and is in the opposition period are you able to oppose it. Any opposition also should be filed by the 2-month deadline, since IP Australia is unlikely to extend that deadline unless there are exceptional circumstances that justify an extension. So I'll hand it back to Sophie now to talk about what happens if your trademark application is opposed. I'll then go through some reasons why you may decide to oppose the registration of a trademark filed by another party.
Okay, thanks, Graci. So if your trademark application is opposed, the first piece of correspondence you will likely receive from IP Australia is a copy of the Notice of Intention to Oppose, or the NIO. So an NIO is really just that, a notice that a third party intends to oppose your application. And at this point, you'll need to start thinking about how important this brand is to you and your business and whether you wish to defend the opposition. So it's a good idea at this stage to do a bit of research on this third party and see what kind of trademarks they're using and what trademark rights they may have already. We also recommend seeking legal advice on your options and prospects of successfully defending the opposition. Now, 1 month after the third party files their NIO, they'll need to file a Statement of Grounds and Particulars, or an SGP. This sets up the legal basis of the opposition, as well as some brief facts which substantiate their claims. So once they file the SGP, this is when the opposition is formally taken to be filed. Once you receive a copy of the SGP, you will then have 1 month to file a notice of intention to defend, or an NID. There's no fee to file this, so sometimes it actually can be a good idea to file your NID in order to preserve your position in the opposition, particularly if you require more time to consider your options or obtain legal advice or perhaps commence private negotiations. If you don't file a notice of intention to defend, the opposition will be considered successful and your trademark application will lapse and will not progress to registration. So this means that your trademark would not be protected. Sometimes defending an opposition before IP Australia can also be a good opportunity for you to show the opponent that you are actually properly entitled to registration of your own trademark, perhaps through use of the trademark that the opponent is not aware of. And if you demonstrate this, it could ward off more expensive actions through the courts. Ultimately, it's really important to understand that the opposition process can have significant implications for your business. It can affect your branding strategy, your market entry plans, and also your legal rights associated with your trademark. So we really highly encourage proactive management of opposition proceedings to protect your business interests. Graci is now going to touch on some of the reasons for why you may want to oppose a trademark application filed by someone else.
Okay, so on the flip side, you might become aware of a trademark that has been filed, and you might have some concerns about the other trademark. So importantly, when commencing or starting an opposition, you'll need to make sure that it's based on one or more grounds prescribed under trademarks legislation. Sophie will go into more detail later on about each ground that could be relied on in an opposition, but some common reasons for when opposing that we see include when, for example, the pending trademark is the same or very similar to a trademark that you've registered or applied for before them. It could be when the pending trademark you believe is likely to deceive or cause confusion due to the reputation of your trademark. And also when you have reason to believe that the applicant of the pending trademark is not the true owner. So to give you an example, say Cindy sells dog treats and has been using the brand Happy Bark for 8 years. Cindy's been told that there's a new pet food business by the name Happy Bark Treats run by Patrick. And after searching IP Australia's database, she sees that Patrick has actually applied for a trademark to protect the name Happy Bark Treats, which has been accepted by IP Australia. So once Patrick's application is in the opposition period, Cindy will need to decide whether to formally oppose the application within the 2-month deadline and on which grounds her opposition will be based. So in this scenario, ideally, Cindy would have an existing trademark for Happy Bark that she could rely on as one of her grounds for opposing, which is the first reason I mentioned before. Even without an existing registration or application, though, she could still have other grounds to oppose. So, for example, where she believes that she has acquired a reputation in the name and therefore use of Happy Bark Treats by Patrick might deceive or confuse consumers. Since Cindy has been using the name for 8 years, she could also show that she used the trademark before Happy Bark Treats was filed, and therefore argue the other party, Patrick, is not the true owner of the trademark. Back to you, Sophie.
Thanks, Graci. So now that we've considered some of the common reasons for opposing the registration of a trademark, we're going to spend a bit of time exploring the legal basis for initiating an opposition, or in other words, the grounds of opposition. So I'm going to briefly explain when each ground may be relevant and run through some examples along the way. And from the outset, I should note that these grounds are specified in the Trademarks Act. So Section 39 of the Trademarks Act may be appropriate to raise as a ground of opposition where the trademark contains a prescribed or prohibited sign. So some words and symbols are protected under domestic or international law, such as the words copyright or patented and the coat of arms of cities and towns in Australia. So it prohibits any trader from being able to obtain protection for these signs and symbols as their use is regulated. We don't frequently see this ground selected though, because issues like these would usually be raised during the examination stage of a trademark application. Section 41 may be raised when the trademark is not capable of distinguishing an applicant's goods or services. And again, this is usually raised and addressed during the examination stage by IP Australia. But if it is either not raised during examination or the applicant perhaps overcame the issue during examination, then this ground of opposition would put the applicant to the test of again proving or providing evidence to show that the mark has acquired sufficient distinction. So for example, in the case of Ocean Spray Cranberries and Sunraysia Natural Beverage Co., the trademark Ruby's Red was used in relation to fruit juices and non-alcoholic beverages. And this was opposed on this ground, on the basis that Ruby Red indicated a particular variety of grapefruit. So the opposition was successful as the trademark was considered to lack the required distinctive quality to function as a trademark. Section 42. So this will be relevant where a trademark is scandalous or contrary to law. Now, this is broken down into two subsections. Section 42A deals with scandalous marks. And when considering whether a trademark is scandalous, the question to ask here is whether the trademark is shameful, offensive, or shocking. And naturally, this can change over time. So some words which may be used to cause offense might no longer be considered shocking. So it really depends on the context of the ordinary people it could offend. Section 42B is the second subsection there. So this deals with trademarks that are contrary to law. So here you would look at whether the trademark contains or consists of any sign which is precluded by a piece of legislation, such as a breach of Australian consumer law by way of misleading and deceptive conduct, or a breach of copyright law, or the tort of passing off. Section 43 is also relevant where the trademark is likely to deceive or cause confusion. And this may occur where the use of the trademark creates a connotation that perhaps draws an association with something where there in fact is no association or authorization. So for example, if your trademark includes a well-known athlete's name and you sell sporting goods under this trademark without their authorization, this ground of opposition may be raised as it is likely to deceive consumers into thinking that the brand has some endorsement by the athlete. And this could also arise when an applicant has attempted to register a domain name that they don't own as a trademark. So that could therefore be misleading to the general public. Now, Section 44, this arises when a substantially identical or deceptively similar trademark already exists on the register for similar or closely related goods and services. And this is one of the most common grounds of opposition, as opponents will often already have some trademark protection on the register. Under this ground, it can also be important to take into account the circumstances in which the marks will be used, the circumstances in which the goods or services will be bought and sold, and the character of the probable consumers of the goods and services. So, for example, if you've applied to register the mark Tranquil Spa, but the opponent to your application has already registered the trademark Tranquility Spa, in respect of similar services such as facial and body treatments and wellbeing services, This ground will be applicable as the trademarks would likely be considered substantially identical or deceptively similar, and the services offered under each trademark are similar. And in addition, the types of customers searching for these services are likely to be in a similar frame of mind. So the next ground we'll consider is section 58. This is relevant where an applicant is not the true owner of the trademark or the opponent has earlier use of a similar mark. Now, to make out this ground, the marks have to be substantially identical, so not just deceptively similar, and they have to be in relation to goods and services or services which are the same kind of thing. Now, as an aside, this is a key benefit of registering your trademark, as the threshold for similarity is lower, so greater avenues are open to you to challenge third-party use. An example of where the marks were found to be substantially identical was in the case of PB Foods and Melanda Dairy Foods, where chill and choc chill were both used in respect of chocolate-flavoured milk. So in that case, in choc chill, the word choc was considered to be purely descriptive. So in essence, the marks were considered to be substantially identical. Oppositions on this grounds can also often arise when the parties are known to each other and there is a dispute about who is the true owner. For example, where two business owners may be in disagreement over who developed a trademark and who is therefore the true owner of the trademark, particularly if one director leaves the business. Another example of where earlier use can occur is found in the case of mini menus. So in this case, there were two startup businesses that operated in different states in Australia, and they offered the same kind of products, and they were initially unaware of each other's existence. Now here, the opponent was found to be the true owner of the mark based on slightly earlier use, which included small things like obtaining quotes from a supplier, engaging a printer to produce some business cards, and approaching some potential customers. So it doesn't have to be much. The next ground is section 58A. And this is relevant for when an applicant has already overcome issues of similarity with another trademark that were raised during examination of their trademark application. And so there, the applicant has already demonstrated evidence of their prior or honest and concurrent use to overcome the objection. So this ground would allow an opponent to prove that they have actually used their mark even before the first use that the applicant outlined in their evidence. And so they are the true owner. Section 59. Now, this is relevant where an opponent believes the applicant has no intention to actually use the trademark they have applied for. It's worth noting that this is a very hard ground to establish, as there is a presumption that a trader intends to use a mark once an application is filed. But this ground could be relevant where an application is made simply with the intention of later selling the trademark to a third party, or where there's no intention to use the trademark in respect of the full range of goods and services for which registration is sought. So, for example, if an established accounting firm sought to register their trademark in respect of both accounting services and real estate services, their application may be opposed on this ground on the basis that the applicant has no intention to use the mark in relation to real estate services. However, again, this will be likely difficult to establish, as an applicant is given a period of time after filing to actually start using a trademark before it is vulnerable to removal for non-use. So an opponent here would need to have a really good reason to suggest that the accounting firm did not intend to branch out into offering real estate services in the next few years. So sometimes this can arise when the businesses are already known to each other. The next ground, section 60. So this would be an appropriate ground to raise when the applied for mark is likely to deceive or cause confusion amongst consumers because of the reputation of another trademark. So this is particularly useful for well-established brands that have such a strong reputation in a well-known mark that if anyone else used the mark or something similar in relation to any kinds of goods and services, it would be likely to cause confusion. So for example, McDonald's was able to successfully oppose an application for McBaby on this ground, despite not owning a trademark registration for this particular term, and despite the fact they weren't even using it. The mark was sought to be registered in respect of a range of games, toy things, and confectionery. And because McDonald's is so well known by its Mac prefix, the delegate in that opposition concluded that the use of any type of Mac language would be immediately recognized as being associated with McDonald's. So the use of McBaby by an unrelated trader was likely to cause confusion. Section 61 allows for an opposition on the basis that a trademark includes or consists of an indication of false geographical origin. So this may occur where a trademark includes a sign that identifies the goods as originating in a country or in a region or locality in that country when they in fact do not originate from that area, especially where a particular quality or reputation or other characteristic of the goods is essentially attributable to their geographical origin. Now, some important considerations here are that this ground only applies to goods and not services. And the geographical indication must also be formally recognized by some government body in the country of origin. So recently, the European Union requested legal recognition and protection by Australia of a large number of geographical indications for some different types of food and spirits, such as prosciutto di Parma and cognac. Essentially, they've sought to stop traders in Australia from using terms like this as part of trademarks in respect of products that don't actually originate from those particular areas in the EU. Now, the Australian government hasn't yet made a commitment to protect these EU geographical indications, as the free trade agreement negotiations actually fell through at the end of last year after receiving a large number of public oppositions from Australian producers. But there is a chance that negotiations may resume in future, particularly as the EU's free trade agreement with New Zealand recently came into effect, and the Australian government might want to revisit it, as it could mean that Australian geographical indications could be protected in the EU in the same way. Okay, so moving on to section 62. This is applicable where a trademark application is defective. So this could be where the application was amended in a way that is impermissible, for example, by broadening the scope of goods and services. Or it could be where the application was accepted actually on the basis of false evidence. So if there's anything in the applicant's evidence that was filed to overcome an objection during examination, which is misleading or false, then this ground could be raised. And finally, section 62A allows for an opposition where an application is made in bad faith. So this may be where there's some kind of history or ill will between the parties, and it requires a consideration of the subjective intention of the applicant when they filed the application. Right, so a statement of grounds and particulars doesn't require the submission of evidence, but the opponent will need to substantiate these claims later in the evidence stages of the opposition, which Graci will discuss in a moment. So I'm going to now pass back to Graci, who is going to walk us through the stages of an opposition and some other practical considerations.
Wonderful, thanks, Sophie. So I'll spend some time now on each stage of the opposition process and how the life cycle of an opposition to registration matter actually looks like. So using the same example from before, if Cindy decides to oppose Happy Bark Treats, the first step for her is to file a notice of intention to oppose, as Sophie mentioned before, or an NIO. And that's a brief notice or form which indicates her intention to oppose the registration of the trademark. The relevant fee must be paid to IP Australia when filing an NIO, which is currently $250, noting if you are opposing multiple trademarks, that the fee is per trademark. And there is an online form available for you to file an NIO electronically through IP Australia's portal. Importantly, once an NIO has been filed, Cindy will then have a further month to file a statement of grounds of particulars, or an SGP, which, as Sophie mentioned, will briefly set out the legal grounds and facts on which her opposition is based. Each ground is different, and Cindy will need to provide brief reasons that are specific to the grounds that she has chosen to include. So a month is not a lot of time from filing the initial NIO, so it's a good idea to get advice from an IP professional well before the initial notice to oppose is filed, so you understand what grounds you have to rely on. Again, an SGP will be filed electronically, and there's now an online form available where you can follow the prompts and put in the information for the SGP directly in IP Australia's portal. Bear in mind that an SGP must be filed for the opposition to formally begin. If it's not filed, there'll be no opposition, and the trademark will proceed to registration as if there was no NIO filed to begin with. So once Cindy's SGP has been filed, IP Australia will assess the SGP to make sure there is sufficient information provided for each ground chosen. IP Australia will then provide a copy to Patrick, and from there, Patrick will have a month to file a notice of intention to defend, or an NID. So similar to the initial NIO, this is a brief form that will indicate Patrick's intention to defend the opposition. Unlike the NIO, there's no fee associated with filing an NID. Importantly, if Patrick doesn't file an NID, his trademark will lapse and won't be registered. So assuming Patrick files the NID before the deadline, the opposition proceedings will then proceed to the evidence stages, where each party will have an opportunity to support their case with evidence. So the first evidence stage will be for Cindy to file evidence in support of her opposition within 3 months. So this is an opportunity for her to provide evidence that substantiates the grounds that she has chosen in the SGP. And that could be evidence, for example, that demonstrates how the trademark Happy Bark was chosen, when it was first used, and how it has been used over a continuous period. So that could be examples of product packaging, social media, website marketing, and annual sales and advertising figures. So once Cindy's evidence in support has been filed, a copy will be given to Patrick. Patrick will then also have 3 months to file evidence in answer. And this is an opportunity for Patrick to then provide evidence that supports his case. So that could include evidence that rebuts or contradicts any information that was included in Cindy's evidence. The final evidence stage then goes back to Cindy, where she has the option of filing evidence in reply to Patrick's evidence within a 2-month period. Now, some important considerations that you should be aware of when filing evidence in an opposition is that submission of evidence is subject to strict deadlines. And as mentioned earlier, requesting an extension or additional time is very difficult unless IP Australia is satisfied. There are exceptional circumstances that apply. In terms of formalities, bear in mind that any evidence must be in the form of a declaration. Annexures or exhibits must be labelled clearly and referred to in the declaration itself. Also, all evidence must be filed electronically through Objective Connect, which is a separate website, file sharing website used by IP Australia. All right, so once the evidence stages are complete, the opposition proceedings will reach a stage where either party may request a decision within a month based on one of the following options, which could be a decision based on the materials filed, a decision by way of written submissions, or a decision by way of written submissions and an oral hearing in front of a hearing officer, which these days is by video conference. Now, which option you choose will really depend on the circumstances of your matter. So say neither party has filed evidence in the opposition and the grounds or facts relied on aren't particularly complex. Then requesting a decision based on the materials filed may be more suitable in that case. So meaning the hearing officer will only consider the documents that have been filed to date, and there will be no further opportunity to provide submissions to support your case. On the other hand, if evidence has been filed by each party and there are multiple grounds at play, then requesting a decision based on written submissions and an oral hearing will probably give you a better advantage, since it would allow you or your representative to really argue and emphasize the strongest points in your evidence, rather than simply relying on the hearing officer to peruse the evidence and form their own view without further input from you. In an oral hearing, you would also have the advantage of actively addressing any specific concerns or questions that the hearing officer might have. Important to note that the 1 month deadline to request a hearing isn't a hard deadline as such, since either party can still pay the fee for a decision after the deadline passes. And the other party will then have an opportunity to participate and opt in. But if neither party requests a decision and pays the fee, the matter will essentially be in limbo and won't be decided by IP Australia. If or once the matter has been heard, IP Australia aims to issue a written decision within 3 months from having the matter decided based on one of the options I mentioned before. All right, just conscious of time, so I'll go through, this is the last part of the presentation. And here are some other practical considerations that are helpful to know if you find yourself in a trademark opposition. So outside of formal opposition proceedings before IP Australia, the parties can negotiate with each other to attempt to resolve the matter without seeing the opposition all the way through. So this might be appropriate when the parties believe the trademarks are able to coexist and therefore are willing to negotiate an agreement or settlement that allows for coexistence. Where the parties require time to negotiate, a cooling off period may be requested, provided each party consents to it. So cooling off would essentially suspend the opposition for an initial period of 6 months, and that can be extended for an additional 6 months, provided each party agrees. Lastly, if a matter proceeds through to a decision, the successful party may recover some costs incurred in the opposition. So that could be legal fees or IP Australia fees, and that's called an award of costs. Bear in mind that these costs are based on a scale set by IP Australia, meaning there are limits on the amount that may be recouped. So an award of costs will not always cover all the expenses that you incurred during the opposition.
All right, so that concludes the main part of today's webinar. And you might also find our publication on trademark essentials useful, and which you can access by scanning the QR code on the screen now. We also have an upcoming event. So this is on Mastering Trademark Use, a guide to protecting your brand with IP Australia. And that will be held on Thursday, the 22nd of August at 11 a.m. Australian Eastern Standard Time. So if you'd like to register for that, you can follow the link on the screen as well. So we're going to get into some Q&A shortly. And while you continue to submit your questions, we'll just take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business can get unlimited access to our full team of 100+ specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Some of the things our team can assist with are unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registrations. We also offer a dedicated service for our in-house teams and for general counsel to manage your high volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business, and we work as an extension of your in-house legal function. So if you'd like to learn more about how our membership or desk extension can help you, feel free to request a free consultation when the survey appears at the end of this webinar.
All right, we'll get into some of your questions now. So I can take the first one here. So we've got someone that's asked, would there be grounds for a successful opposition if a competitor was trying to trademark a similar name, but we have not trademarked our own business name? Would consideration be given if we have been trading under a particular name for 15 plus years? Yeah, so that touches on one of the grounds that Sophie talked about, which is Section 60. So that is where if you can demonstrate that you have a reputation in a trademark despite not having it registered, and therefore use of the other trademark applied for might deceive or confuse consumers, that's a potential ground that you could rely on. So it doesn't require you to have a registration, but you would need to show that you have been using the trademark for a number of years and consumers, and you've built a reputation in that trademark.
Okay, I can take the next one that's come in here. So it's a question on international oppositions. So someone's asked, how can I stop someone from registering my trademark overseas? Is the opposition process the same in each country? So it's a good question because in this webinar, we focused on the Australian opposition process, but the opposition and registration process in each country is slightly different. And crucially, a key thing to remember here is that there are different timeframes in which you can actually file an opposition from the date that the application is published. So while it's 2 months in Australia, like we've spoken about, in New Zealand and the EU, for example, the opposition window is 3 months. Some countries, the opposition period is actually before the formal examination of the application. So what I'd really encourage you to do is engage the assistance of a local agent in that country if you're monitoring a particular trademark application, or if you just want to set up a general watching service, so that you don't miss that opportunity to oppose. And I guess it's also worth mentioning here that another important step you can take to stop others from registering your trademark in your target markets overseas, or at least make it harder for them to do so, is to register your trademark first. So this will likely block any new applications before they even get to the opposition stage. So that's worth bearing in mind as well.
All right, I can take the next one. So we have a question, how long does an opposition take? So if all stages of the opposition are completed within the relevant timeframes and the proceedings go all the way through to the final hearing or decision stage, the entire process could take anywhere between 1 to 2 years before a decision is made by IP Australia. It will take longer if any extensions of time are granted, although, as mentioned, extensions are very rare and ideally shouldn't be relied on.
Alrighty. One's come in here about, okay, so they've asked, what happens if I want to object to a trademark application, but I miss the time that I can file an opposition? All right, so if you've missed the opposition window, what will likely happen is the trademark will progress to registration. And if it does, there are some other steps you can take to apply to, say, cancel the registration through court proceedings. But obviously that's not ideal. Court proceedings can be very lengthy and costly. So it's worth keeping in mind there is a 10-day grace period between the end of the opposition period and then when a trademark actually is registered. So if you're only a few days out from that opposition deadline, you may be able to seek an extension of time to oppose within that grace period. Just on that though, as Gracie mentioned earlier, you'd need really good reasons for why you weren't able to oppose during the original 2-month window. And what's usually required there is for you to submit a declaration explaining that there's perhaps been an error or omission on your part or your employee's part or an agent's part, or that there were circumstances that were kind of beyond your control that prevented you from filing within that time. Once the trademark does progress to registration, though, at that point you can't seek an extension of time, so you would need to consider court action if it's got to that point already.
All right, we've got a question here. What are the chances of someone opposing my trademark? So as a general comment, facing trademark opposition is not very common in Australia. So some factors that might impact the chances of receiving opposition will be the trademark that you've applied for and the industry that you're operating in. Of course, if there is an existing brand out there using the same name, then the chances of receiving opposition could be higher. In that case, it's a good idea to be a bit more proactive and take certain steps to hopefully reduce the risk of opposition or the risk of your application being opposed. So that could be, for example, limiting the scope of your goods and services at the outset in the hopes that that will preemptively reduce or allay any concerns that the existing brand might have. Ultimately, I'd say oppositions are often unpredictable since it is down to the other party or trader to decide if there is enough concern to oppose. From my experience, though, the parties will often resolve the matter outside of the formal proceedings rather than seeing the opposition all the way through.
All right. Now, we've had one question come in about a different type of opposition. So the question was, how much do you need to use a trademark for it to be covered and not removed for non-use? Okay, so this relates to the opposition to a removal application, which we didn't explore in detail today, but Graci did mention that this was a type of opposition. And essentially, this is where a third party may have applied to remove your trademark registration on the basis that it's not in use. And we didn't touch on the grounds of opposition that are applicable in this situation. But essentially, it's open to you as the owner of a trademark registration to oppose the removal application if you've used your trademark within a relevant period. So the question of how much use you need to have is really going to be dependent on your particular circumstances. Generally speaking, you'd want to ensure you can demonstrate that you've used the trademark publicly and for a genuine commercial purpose to actually promote or provide your goods and services. And this can be a relatively small amount of use as long as it is within the relevant 3-year period preceding the removal application. But because this does really depend on your particular circumstances, and we didn't explore this in a great detail today, I just encourage you to book in for your consult so we can discuss this further. Yeah, there's quite a few intricacies surrounding this type of opposition, so hopefully we can speak to you after this.
Right, we'll try and get through one or two more questions. So I've got one here where someone has asked, what is the format for evidence when providing documents in a hearing? So I touched on this in the presentation, but evidence given in an opposition needs to be in the form of a declaration, which is usually completed by the applicant or the owner, or if the applicant is a company, then a director or other authorized person of the company. Annexures or exhibits must be clearly referred to in the declaration. And IP Australia, as I mentioned before, requires that evidence is filed electronically through their website, Objective Connect. So when you reach the final hearing or decision stage, there is no option to file any new evidence. Bear that in mind. So if you decide to request a decision based on written submissions or an oral hearing, the only additional documents that you should file then are the written submissions or legal arguments, which don't need to be in a specific format, but are generally prepared by a professional who will probably have their own structure for setting out the submissions in a way that emphasizes the points in your case. All right, might have time for one more question.
Yeah. Okay. So we have got quite a few questions that have come in. So apologies if we don't get to all of them today, but please do make some inquiries after this. We'll try and get back in touch with you. There's one that's just come in based on the kind of the timing of filing a notice of intention to oppose and the statement of grounds in particular. So it just touches on what I've explored earlier in terms of when an opposition is formally taken to be filed. So the question was, what happens if you don't file a statement of grounds and particulars? I thought filing the notice of intention to oppose was enough. And this really it's an important distinction here. So filing the notice of intention to oppose, as I said, it's just an administrative kind of part of the process. Filing the statement of grounds and particulars is when the opposition is formally taken to be filed. Because you essentially have to provide the reasons and the legal basis of your opposition so that the applicant can make an informed decision about whether to defend it. So if you've already filed your NIO, I really strongly encourage you to engage a trademark professional to help you prepare the SGP now. Sometimes a really strong SGP may be enough to win the opposition. The applicant might not even decide to file a notice of intention to defend after that. So it's really important to get that SGP right and be really comprehensive with your claims, as this is the framework really for setting you up for the later evidence stages.
All right, I think that's all we have time for today. Sorry if we haven't answered your questions, but please submit your details in the survey at the end for assistance with any questions that we didn't answer and to learn more about how our membership can help you. And while this is a free webinar, we'd really value your feedback. So we'd be grateful if you could please complete the 30-second survey at the end. Thanks so much for joining us and have a great rest of your day.
Thank you.